Hello everyone, today we are going to learn about Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006. Let's learn through PYQs. So the question is, which of the following statements relating to Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006 are correct? Statement 1. The Act recognizes forest rights of forest-dwelling scheduled tribes who have been occupying the forest land before October 25, 1980. Statement 2. The onus of implementation of the Act lies at the level of state UT governments. Statement 3. The Act seeks to recognize and vest certain forest rights in forest-dwelling scheduled tribes and other traditional forest dwellers. Asking the correct ones. This statement 1 is incorrect. The date is not October 25th, 1980. It is December 13th day of the December 2005. Okay, so this is correct. This is also correct. As the incorrect ones, option B is right answer. 2 and 3. Let's see. So this act is an act to recognize and vest the forest rights and occupation in forest land in forest dwelling scheduled tribes and other traditional forest dwellers who have been residing in such forests for generations but whose rights could not be recorded. And the onus of implementation of the act lies with state or UT governments. This act also defines forest-dwelling scheduled tribes, means the members or community of the scheduled tribes who primarily reside in and who depend on the forests or forest lands for bona fide livelihood needs, and includes the scheduled tribe pastoralist communities. And also defines other traditional forest dwellers, means any member or community who has for at least 3 generations prior to the 13th day of December 2005 primarily resided in and who depend on the forest or forest land for bona fide livelihood needs. And as per the section 4 of the act, the recognition and vesting of the forest rights under this act to the forest dwelling scheduled tribes and to other traditional forest dwellers in relation to any state or union territory in respect of forest land and their habitat shall be subject to condition that such scheduled tribes or tribal communities or other traditional forest dwellers had occupied forest land before the 13th day of December 2005. So the date is mentioned here before the 13th day of December 2005, and here they are saying that before October 25. So this why statement 1 is incorrect. Let's move to another question. This question was asked in CSE 2019. Statement 1. As per the recent amendments to the Indian Forests Act 1927, forest dwellers have the right to fell the bamboos grown on forest areas. Statement 2. As per the Scheduled Tribes and other traditional forest dwellers Recognition of Forest Rights Act 2006, bamboo is a minor forest produce. Statement 3. The Scheduled Tribes and other traditional forest dwellers Recognition of Forest Rights Act 2006 allows ownership of minor forest produce to forest dwellers. Asking the correct ones. So this is incorrect. This is not forest areas. It is non-forest areas. Non-forest areas. Okay, so this is correct. This is correct. So option B is right answer. 2 and 3. Let's see. Indian Forests Amendment Act 2017 exempted bamboo grown in non-forest areas from the definition tree, thereby dispensing with the requirement of obtaining a permit for felling of bamboo for economic use. Bamboo grown in the forest areas. So remember, bamboo grown in the forest areas shall continue to be governed by the provisions of the Indian Forest Act 1927. So still in forest areas, it is governed by the Indian Forest Act 1927. This act also defines minor forest produce, includes all non-timber forest produce of plant origin, including bamboo, brushwood, stumps, cane, tussar, cocoons, honey, wax, lake, tendu leaves, medicinal plants and herbs, roots, tubers, and the like. And it bears the right of ownership, access to collect, use, and dispose of minor forest produce which has been traditionally collected within or outside village boundaries. Move to another question. At the national level, which ministry is the nodal agency to ensure effective implementation of the Scheduled Tribes and other traditional forest dwellers Recognition of Forest Rights Act 2006? Option A, Ministry of Environment, Forest and Climate Change. Option B, Ministry of Panchayati Raj. Option C, Ministry of Rural Development. Option D, Ministry of Tribal Affairs. So option D is the right answer, Ministry of Tribal Affairs. So section 11 of the act talks about nodal agency, the ministry of the central government dealing with tribal affairs or any officer or authority authorized by the central government in this behalf shall be the nodal agency for the implementation of the provisions of this Act. The Ministry of Tribal Affairs, being the nodal ministry for administering the legislative matters of FRA, by exercising power under Section 12 of the Act, has been issuing directions and guidelines from time to time on various aspects to ensure proper implementation of the Act. Let's solve this question. Under the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006, who shall be authority to initiate the process for determining the nature and extent of individual or community forest rights of both? Option A, State Forest Department. Option B, District Collector, Deputy Commissioner. Option C, Tehsildar, Block Development Official or Mandal Revenue Official. Option D, Gram Sabha. So right answer is option D, Gram Sabha. Let's see. Section 6 of the Act talks about the authority to vest forest rights in forest dwelling scheduled tribes and other traditional forest dwellers and procedure thereof. So the Gram Sabha shall be the authority to initiate the process for determining the nature and extent of individual or community forest rights, and it shall pass a resolution to that effect and thereafter forward a copy of the same to the subdivisional level committee. Let's move to another question. Consider the following statements about the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006. Statement 1, it does not recognize individual rights like rights of self-cultivation. Statement 2, it recognizes the community rights as grazing and fishing. Statement 3, it ensures land tenure, livelihood, and food security of the forest-dwelling scheduled tribes and other traditional forest dwellers. Statement 4, it protects the tribal population from eviction without rehabilitation and settlement. So asking the not correct ones. Always highlights a keyword. Okay, so 1 is does not recognize, so it is wrong. 2 is correct, 3 is correct, 4 is also correct. So asking not correct, so D is the right answer. Let's see. The Act encompasses rights of self-cultivation and habitation, which are usually regarded as individual rights, and community rights as grazing, fishing, and access to water bodies in forest, habitat rights for PVTGs, particularly vulnerable tribal groups, traditional seasonal resource access of nomadic and pastoral community, access to biodiversity, community right to intellectual property and traditional knowledge, recognition of traditional customary rights and right to protect, regenerate or conserve or manage any community forest resource for sustainable use. It also provides rights to allocation of forest land for development purposes to fulfill basic infrastructural needs of community. Objectives of the Act: to undo the historical injustice occurred to the forest dwelling communities, to ensure land tenure, livelihood, and food security of the forest dwelling scheduled tribes and other traditional forest dwellers, to strengthen the conservation regime of the forests by including the responsibilities and authority on forest rights holder for sustainable use, conservation of biodiversity, and maintenance of ecological balance. And this is the section 3, which talks about the forest rights of the forest dwelling scheduled tribes and other traditional forest dwellers. Okay, this act also defines the community forest resource and also critical wildlife habitat. And there is one act, that is the Wildlife Protection Act, which also defines the core or critical tiger habitat. So what is the difference between critical wildlife habitat or core or critical tiger habitat? Let's see. Section 38B of the Wildlife Protection Act 1972, as amended in 2006, explains the core or critical tiger habitat as well as the buffer or peripheral area of a tiger reserve. A tiger reserve includes two parts: core or critical tiger habitat or buffer or peripheral area. The phrase core or critical tiger habitat is mentioned only in Wildlife Protection Act 1972 as the sequel to amendment made to the Act in 2006. It is not defined in the Forest Rights Act 2006. It is notified by the state government in consultation with an expert committee constituted for the purpose. Core or critical tiger habitat is different from the critical wildlife habitat since tigers are territorial big cats, hence considering their social and tenure dynamics, the core or critical tiger habitat has been viewed separately from the critical wild habitat, which is applicable to other wild animal species. The phrase critical wildlife habitat is defined only in the Forest Rights Act 2006 and not in the Wildlife Protection Act 1972. The identification and declaration of critical wildlife habitats are two distinct processes, while the identification of an area required for betterment of wildlife conservation is purely a scientific exercise to be carried out by the forest departments on a case-to-case basis in consultation with scientific institutions. Its notification is to be done only after extensive consultations, means consent with the Gram Sabha and affected persons stakeholders. So this is very important, can be asked in your upcoming exams. Thanks for watching. Have a good time ahead.